please. Good morning and welcome to the First District Court of Appeal. We'll have 4 cases on our docket for argument today. I'm going to take about a 10-minute break after the second case, between the second and third cases, at which time, if you like, counsel are invited to join the court in the lawyer commons to your right for coffee and conversation on topics, of course, other than today's or tomorrow's docket. I also want to welcome anyone who's watching on our worldwide webcast. This is something we've been doing now for some time, and we hope that the bar finds it instructive and that it adds sort of to the whole openness and transparency which the courts are rightfully striving for. First case is Johari Harold versus State of Florida. Counsel for the defendant.
Good morning. May it please the court, my name is Edward Bauer and I represent the appellant Johari Harold. We're before the court on an appeal from the appellant's conviction for aggravated battery with a deadly weapon. If I could please reserve 2 minutes for rebuttal. I'm prepared to provide the court with a brief statement of the facts, or if it would prefer, I could proceed directly into my argument. I think we have a number of issues.
That's at your discretion. The court has read the briefs and is familiar with the what I always say is if the court's not familiar with the facts of record, you got a really difficult task ahead of you.
I understand, Judge. We essentially have 3 arguments, Judge. The first is that the trial court abused its discretion by allowing the state to introduce into evidence photographs and testimony concerning the extent and nature of the victim's injuries. And on this point, I'm confining my remarks to the injuries caused by the appellant. Our second argument is the trial court abused its discretion by allowing the state to introduce photographs and testimony concerning injuries sustained by the victim at the hands of an independent assailant during a previous attack. And our third argument is somewhat related in that it concerns medical testimony that the victim provided concerning medical treatment that he received in the months following the attack. With respect to the first argument, it's been the law of this district since 1990 when the court decided D.C. v. State that evidence concerning bodily injury is irrelevant in prosecutions for aggravated battery with a deadly weapon. The state in this case did not charge the appellant with causing great bodily harm. Perhaps they could have, or they could have charged it in the alternative. They did not. They simply charged him with aggravated battery.
Isn't the law fairly clear now that the question of whether a particular implement is a deadly weapon is generally, in the absence of undisputed evidence or stipulation, is generally going to be a jury question, and the state has a bit of leeway in demonstrating whether a particular weapon is, in fact, a deadly weapon?
This court has held in the past that it does not. In D.C., I believe the facts of that case were that the juvenile sprayed deodorant right in the face of a counselor. I think it was at Father Flanagan's boys' home here in Tallahassee way back when. But anyway, the victim couldn't catch her breath, had to go to the hospital, and had to receive treatment. And in reversing the adjudication of delinquency, the court pointed out that the state didn't have its correct focus. The focus should have been on the question of, is spraying deodorant in someone's face at close range, is that likely to cause great harm? Not, did it actually cause great harm? And what the court pointed out in its analysis is that, well, the state did present evidence of harm. They presented evidence she couldn't catch her breath, she had to go to the hospital, she had to retreatment, but the court said that evidence is irrelevant, because that is not the issue. The issue was, and what the state should have focused on is when you spray deodorant at close range, is it likely to cause such harm? And they flat out held that the evidence of injury was irrelevant. Now, whether, I'm sure the state would suggest that perhaps that decision was not correctly decided, particularly in light of what the 4th District did in 1996. And I don't know if the court would like me to address that issue, but I believe the decision is correctly decided. It relied on decisions from the 5th District, or I actually only one. I think it was the Lee decision from 1984, which, as far as I can tell, was the first decision in Florida to address this issue of what's admissible in these sorts of prosecutions. And this court explicitly relied on Lee, which, as far as I can tell, is still good law in the 5th District. Lee was cited again in 1992 by the 5th District in reversing an aggravated battery conviction in the, I believe it's the Webb decision. And, of course, the state has raised a question of whether it's still good law in the 5th District. In 1999, in the Brooks decision, the 5th District didn't even acknowledge either of those opinions and followed the 4th District in TB, but they never en banc Lee or their previous decisions. They've never expressly overruled the proposition or their previous holding that this evidence is not irrelevant in these prosecutions. So if the court continues to adhere to the holding in D.C., there's no question that the trial court erred in allowing this information to be introduced.
Well, to what extent, though, is our decision in D.C. sort of a JOA type of case? You just didn't put on the evidence to sustain your burden of prima facie aggravated battery.
But I think what was important is that...
Isn't that what it is?
It's what it is, but the court specifically held that the evidence that they did present, which was bodily harm evidence, was not relevant to the crime charge. And that's my point here, that the court admitted irrelevant evidence. If the injury the victim sustained in D.C. was irrelevant for the same sort of charge, then this has to be irrelevant as well. It's a different sort of injury, but it is nevertheless injury. Had the state charged it in the alternative or charged him with great bodily harm, obviously we wouldn't have an argument. But for whatever reason, they decided to charge this as just a deadly weapon case. So the focus is on the likelihood. In other words, how was the defendant wielding the object? How did he swing it? And there was ample testimony. There was an independent eyewitness. The bouncer at the nightclub testified that the appellant picked up the stool by the end of the legs and crashed it down over the head of the victim. The defendant's testimony was slightly different. He said he held it in the middle of the stool and threw it at the victim's head. But regardless of which version the jury accepted, I think the evidence was more than adequate to show that what he was doing was perhaps likely to cause great harm, and that the evidence of the injury was irrelevant and completely unnecessary. And I don't know what the court's intentions are, if they intend to perhaps en banc this case and reconsider D.C. as the state has suggested, and I would ask the court not to do that, and if it did...
Well, you'd really have to persuade me that the comment about what other states have done with this evidence is more than dicta in the context of a case where I really think they're talking about the sufficiency of the evidence. I don't know what the state will say about that, but that's kind of the way I look at that case.
Is the court referring to D.C.?
D.C. Sufficiency of the evidence case.
That is true. They held that the evidence was insufficient, but in reaching that holding, they pointed out that the only evidence presented was bodily injury evidence, and the court explicitly held that bodily injury evidence is irrelevant for this sort of charge. The only difference between D.C. and this case is the type of injuries received.
Would you concede that there's not a holding in that case that the evidence of injury to that particular victim was wrongfully admitted?
They didn't actually hold it was wrongfully admitted, but they did, from my recollection of the wording, what they held was other courts, and they were referring to the 5th District and
but I mean, before this court would go en banc to overrule a precedent, we'd have to be real convinced that we had a controlling precedent that applied, to a number of other cases.
The court did not hold that it should not have been admitted, but what the court held was that the evidence of injury was irrelevant, and I think by implication...
Well, counsel, now, I'm looking at the specific language of the court in the D.C., and I don't see where they say, we hold this is irrelevant. All I see with regard to relevancy is that other courts have found such proof irrelevant. And then it says, we find on the foregoing authority there was insufficient evidence to support the trial court's conclusion. Now, how do you get a holding of irrelevancy out of that?
Well, because they were citing Lee, Your Honor, and Lee held that such evidence was irrelevant, and then they apparently based their ruling on Lee. Lee held that it's not relevant. The court, in concluding in D.C. that there was insufficient evidence to survive a JOA, explicitly held that the evidence shouldn't be considered, that the harm that the victim suffered, and it says other courts have found such proof irrelevant, and then it cites Lee. It seems to me the court was following that case. It might not have used the word hold, but certainly it was relying on that decision in concluding that, and analyzing whether the court was correct or incorrect in denying the JOA, that it would not consider the state's evidence of harm. So whether they held it or not, it seems that this court, at least in one way or the other, adhered to the view that evidence of injury should not be considered in this sort of prosecution. If I could move to our second point, which involves the injury sustained by the victim at the hands of another attacker. the facts are somewhat in dispute, but there's no question that the victim was attacked by another assailant prior to the altercation with the appellant in this case, and that he was struck on the head with a bottle, which resulted in substantial injuries. I believe the court record contains color photographs. From my reading of the record, the B and C, State's Exhibits 1, B, and C, depict the injuries inflicted by that other individual, not by the appellant. It's our contention that, again, and I've cited one case, there are many, the McGriff case, but it's well settled that each person charged with the crime is entitled to be tried on evidence tending to show his or her guilt. And by allowing this evidence, essentially the injuries became the feature of the trial in this case. And not only that, but injuries caused by someone else. And what's important to recognize is that it would seem to me that the state attorney's theory throughout this prosecution was that the appellant and the other assailant were somehow linked and they were acting together. But the court would not give a principal instruction. I cited that in my initial brief. The state attorney argued vigorously for it, but the court concluded that there was no evidence linking the appellant to that other attack and that other individual, and refused to give a principal instruction. So,
is that the reason why the principal instruction wasn't given, or did we just simply have two separate attacks? Because the other person that we're talking about was identified by the victim as the buddy of the defendant.
In rebuttal,
like they had a tag team. One of them took him out with a bottle, and the other hit him with a bar.
I guess that was the state's theory.
Both independent acts.
The court allowed it to go to the jury that way, Your Honor. And the jury was not instructed that the jury could consider the defendant as a principal of what the previous assailant did, right or wrong. He didn't give the instruction. And I think the problem here, and I apologize for not addressing this at greater length in my initial brief, but this error was compounded by the state attorney's second closing argument. And I would refer the court specifically to pages 181 through 183 of the trial transcript. And he actually uses the words, and this would go to the harmlessness of the error, but he focuses at great length on these other injuries in his second closing argument. And he actually suggests that the defendant and the other assailant were acting together 5 minutes after the court refused to give a principal instruction. His exact words are, this happened because these guys decided to jump him. And then what the state attorney did was he went through the injuries and even went so far to suggest that they were acting together, and that perhaps, if the defendant's story was true, that the victim had threatened the defendant with a bottle, that perhaps the first blow would have been permissible in self-defense, but not the second blow, which was inflicted by the appellant. So what he's done is lumped these two individuals, which the court refused to instruct the jury that they were acting together or possibly acting together. They're lumped together, and I don't see any way that this did not affect the jury's analysis of the defendant's self-defense claim, particularly where the prosecutor in his second closing argument is lumping them together, suggesting they acted together, and even suggesting that perhaps Mr. Bryant, the first attacker, that his actions were justified in self-defense, but not the defendant's. And to me, I don't see how the state could demonstrate that that's harmless beyond a reasonable doubt. Essentially, it was a free-for-all where all this evidence was admitted, and the state essentially was, the way I read pages 181 through 183, if the court would refer to those at a later time, essentially lumping these two individuals together and almost asking the jury to find the appellant guilty based on Mr. Bryant's conduct. So I would find the error to be harmless, or harmful. And if I could move on to our third point, the victim, and I'll admit that it was brief testimony, but nevertheless, the victim was permitted to testify over objection that he, as a result of this incident, by incident I'm referring to both attacks, the victim never clarified if he needed the CAT scan every 4 months because of the broken bottle over his head or whether it was from the stool, nor did he clarify he needed the plate that was surgically implanted in his skull, whether that was caused by the bottle or whether that was caused by the stool. But nevertheless, this testimony was admitted, and there was no expert testimony presented to sort of separate this out. And there is no question that follow-up medical procedures in this case are not relevant. Not only is the injury irrelevant, but I fail to see how follow-up medical procedures months later could be relevant to show that, or to demonstrate the manner in which the defendant was wielding that bar stool. It seems far removed from that question. I cited one case Scarborough was a 3rd District case, and I believe that was a prosecution for aggravated or battery on a law enforcement officer, and what the court did in that case was allow the state to introduce evidence that the officer had to receive treatments for AZT and penicillin because I believe the victim bit the officer in that case, and the court allowed that evidence. 3rd District reversed, saying...
You're under 1 minute, by the way, just want to...
Okay. If I could just confine my remaining remarks to photograph 1D. I don't know if the court's had the opportunity to observe these photographs, but even if the court holds that the injuries are relevant, and even the injuries inflicted by the other assailant, I'd refer your attention to photograph 1D. I believe that's a highly inflammatory photograph, and the thing about it is, you can't even see the injuries. The injuries are covered with bandages. The victim is essentially lying in a hospital bed, semi-conscious, with blood all over his face, and my viewing of it is that it's highly inflammatory and really has no probative value because you can't even observe the actual cuts. All you can see are bandages. So I believe that perhaps could be separated from the other photographs. If the court does hold that some of the injuries are relevant, that photograph doesn't even depict the injuries. It just basically depicts an unconscious victim in a bed with blood all over his face.
Time's expired.
Thank you.
Usually our clerk will come out and talk to you all. Of course, I wasn't here. I don't know if he did or not, but there's only one time clock, and when it counts down, that's your total time. When that sum up light comes on, you're into the time that you've reserved. So hopefully, he's usually real good about making that clear, and I feel like he probably did today. State.
Thank you, Your Honor. May it please the Court, Thomas Winokur for the appellee, State of Florida, in this case. I'd like to start my remarks by discussing the D.C. case, which was discussed by appellant in his argument here. I would agree that with the Court, with your observations, Judge, that D.C. was not a case regarding the admissibility of evidence. D.C. was a case regarding sufficiency of evidence. What the Court determined in D.C. was that the evidence was simply insufficient to prove that the defendant used a can of aerosol spray as a deadly weapon in that case. Now, it did state that other courts have said that this evidence is irrelevant, and as you observed, it did not actually adopt the rule that it's irrelevant. But what that case was about was that the evidence was insufficient to prove that the weapon was used as a deadly weapon. It never adopted a rule that was irrelevant. The fact that it was irrelevant has nothing to do with whether the evidence was sufficient or not. In fact, the fact that evidence is irrelevant is not supposed to be even considered in sufficiency review. I think that this Court was simply saying that other courts have said this is irrelevant, and this goes to prove
Well,
that...
we don't know, and I didn't specifically ask Mr. Vara, but we don't know, for instance, if there was even an objection.
That's exactly correct, Your Honor. And I think that's probably why the Court stated it the way it did, by saying that this is just evidence that other courts have ruled irrelevant, and by our consideration, this type of evidence just is simply insufficient to support an aggravated battery with a deadly weapon claim, which is pretty consistent with a lot of other cases that talk about the deadliness of the weapon. In that case, it was an aerosol can. I've never been sprayed in the face with a can of deodorant. I've never done it to anybody else, but it's black letter law on...
Focus for a moment on what evidence you put in here. Let's assume, for purposes of this discussion, that the extent of the injury is evidence of whether or not great bodily harm would come from using this particular instrumentality, which, as it sits on the floor, may or may not be considered a deadly weapon. What evidence was there as to which of the cuts, bruises, or injuries was sustained by the stool? What was the relevance of a bandaged head? What was the relevance of all the injuries sustained going in for this court? Other than to show the man was badly hurt in a fight, in a bar, and evoke sympathy from the jury.
Judge, to show that the man was badly hurt was exactly why this evidence was admitted.
What if he was badly hurt from the bottle and he wasn't badly hurt from the stool?
Well,
what evidence was it that he was badly hurt from the stool?
The evidence that he was badly hurt from the stool was combined by the combined testimony of Marcus Farland, the bouncer, who described what it is that the appellant did to Mr. Singleton, and the
All right, then what was the purpose of showing all the other injuries?
The purpose of showing all the other injuries, as the state stated in the argument on this motion prior to trial and in its second closing, was to rebut the appellant's claim of self-defense. What happened in this case is that there was, in fact, some sort of a melee. It's unclear what actually occurred because different witnesses testified to different facts. But what is fairly clear is that Mr. Singleton was, in fact, injured prior to the appellant's attack on him with the bar stool. And the state quite explicitly stated that it wanted those other injuries to be admitted to the jury so they could see that Mr. Singleton wasn't much of a threat to anybody. And what it bore on was the reasonableness of appellant's fear of Mr. Singleton to use deadly force against him, or non-deadly force. And that is exactly why those were admitted. And that's exactly why they were admitted, even though they did show injuries that weren't inflicted by the appellant in this case. Those were what they showed. It would certainly have been an easier case if we had some photographs that reflected the injuries that we know were imposed by appellant and some that reflected the others, and maybe some of those others wouldn't have been admissible. But that's not what happened here. These aren't easy cases. The trial judges here have a hard job deciding when to allow this type of evidence in, and the standard is abuse of discretion, and we'd say that unless it's clearly erroneous, this court should defer to the judge's discretion with that. As far as the photograph with the bandaged head, I didn't hear anything about that at the trial. I don't believe that it was preserved for review, that one of the photographs showed him with a bandaged head. I don't really know how that bears on anything else in this case. But I did want to state that, since I mentioned the deadly force, that the appellant has claimed that it's really undisputed in this case whether the stool was used in a manner likely to produce death or great bodily harm. I would not agree with that characterization. I believe that appellant stated in his own testimony that he picked it up by the middle, and the phrase he used in cross-examination was released it. I don't know if he feels like he just lightly tossed it at Mr. Singleton. That's a characterization that appellant used in closing arguments as well, that it was just released or tossed at Mr. Singleton. And maybe more importantly is that the jury was instructed not only on use of deadly force in self-defense, but use of non-deadly force in self-defense. So it's very clear that the jury was left to decide for themselves whether this stool was used in a manner likely to cause death or great bodily harm. Regarding the question of whether this evidence should be excluded as irrelevant in all cases, the state would simply say that really since TB was decided in 1996, not a single court has held by that earlier rule that said that these were irrelevant. And as far as the TB decisions contention that these are often excludable, even though they are in fact relevant for most purposes, the state stands by its argument that those two things are not inconsistent and that these really are almost relevant in all cases. The fact that they may be excludable doesn't mean that it's irrelevant. Relevant evidence can be excluded for other reasons, such as if it's overly inflammatory or if it's unnecessary or whatever. There are other reasons why relevant evidence can be excluded, and I have failed to think of any kind of a case where, in an aggravated battery of deadly weapon, where evidence of injury would be utterly irrelevant. And I think that this court should reject any per se rule regarding the admission of any evidence, particularly on relevance grounds. As far as the principal instruction, appellant correctly says that the principal instruction was not given to the jury. I would not characterize the prosecutor's argument the same way that appellant did in this argument. First of all, that wasn't preserved. There was no objection to that argument. But second of all, as I stated before, what that argument showed was that he was not acting in self-defense. And any suggestion that they were acting in concert was simply part of that argument, that he wasn't acting in self-defense. As far as the medical treatment goes, It is, in fact, still relevant to the deadliness. It's probably certainly less inflammatory than the photographs were in this case. And I can't believe that appellant would contend that having a doctor come in and testify in great detail as to the medical issues here and the harm suffered by Mr. Singleton would have been any less objectionable to appellant than Mr. Singleton simply stating in very quick terms that he was injured and quickly describing those injuries. And the Scarborough case does not say anything about that because Scarborough was a battery of a law enforcement officer where injury is not relevant. It's not relevant to prove the deadliness of the weapon or anything else. So, in conclusion, the state requests this court find that the trial court didn't abuse its discretion in any of its rulings in this case and affirm the judgment and sentence. Thank you very much.
Thank you, Mr. Winokur, and we will reset the appellant's clock to give you a minute, Mr. Bauer, to wrap up.
Talk fast. Just briefly, with respect to the fourth photograph that was preserved on page 18 of the trial transcript, the assistant public defender objected to all of the photographs based on relevance. I believe that was preserved. With respect to the self-defense argument that the injuries are relevant to refute the defendant's self-defense claim, it's important to recognize that all of that evidence was admitted during the very first witness, and that the defendant did not present an opening statement in that case. His defense counsel waived it. So at the point all that evidence was introduced, self-defense had not even been raised by the defendant. Perhaps it'd be different had it been raised in rebuttal, but this was raised to the very first witness in the state's case in chief when self-defense had not even been brought up at that point. And perhaps by the trial court allowing the state to do so, that very well may have affected the defendant's trial strategy, decision as to whether he testified and whether he called other witnesses. I have 10 seconds left. I can't get anything else. I appreciate it. Thank you.
Thank you, counsel, both of you. Suzanne Deere versus